morning. Hello, everyone. Okay, good morning and welcome. We're conscious of the time. We've invited you here for a prompt 10 a.m. start, and that we will have this morning. We know that the clock is ticking. It's not only ticking for our session this morning, but it's ticking in another sense. We're all gathered here in anticipation of D-Day, which occurs in just 1 week, right? So our session this morning, themed Countdown to Compliance, what you need to know about the Data Protection Act, could not happen at a more opportune time for us all. This is part of PSOJ's unwavering commitment to ensuring the Jamaican private sector, you our members, are thoroughly prepared for the registration with the Office of the Information Commissioner on December 1st as part of the Data Protection Act legislation. PSOJ did a recent survey which found that over 90% of member businesses are unprepared for the Data Protection Act. This finding is a crucial call to action for us because it emphasizes the need for heightened awareness and understanding of the DPA legislation. We're therefore honored and very privileged to have the assistance of the team from the Office of the Information Commissioner here with us today, particularly their representative, Mr. David Gray, who is the Deputy Information Commissioner, whose expertise in information management and privacy protection will be pivotal in guiding us through the intricacies of DPA compliance and personal data protection across our various stakeholders. We will hopefully be joined later in our question and answers section by the Commissioner herself, Ms. Celia Barkley, who is set to join us for that session. So all the questions you have between Mr. Gray and Ms. Barkley, they should be well dealt with. So in 2020, we joined with other Caribbean nations and in fact worldwide in terms of enacting our own data protection legislation, which we believe is a significant step in aligning our digital transformation efforts with global best practices. The DPA enhances our data management practices in an increasingly digital landscape, and we know all the risks that can come with increased digitalization. So our survey, from our survey, we learned that there are unique challenges in sectors such as accommodation, food services, financial and insurance sectors. And we recognize that the DPA's implications vary across various industries. And so it demands tailored guidance and resources for effective navigation. And that's why we're here today, for you to get it from the horse's mouth. You can represent your industry, your particular company, the particular nature of your business in terms of asking your personalized questions. So advocacy on matters like the DPA is vital to our mission here at the PSOJ. Our role ensures that every private sector business comprehends its rights, its responsibilities, and functions under this important act. And this webinar is therefore a crucial initiative for us towards this endeavor. So while there is substantial awareness about the impending deadline, as I said, December 1, our objective today is to deepen the awareness into a comprehensive understanding and proactive preparation. So this is not the first we would have had. We have had various sessions over the last several months, but today we want any final touches that need to be done in relation to our preparation for that deadline. So we know the implications of DPA compliance are extensive, and of course, I would say dare say expensive, and your organizations must grasp these fully. So today's journey towards compliance is more than just fulfilling a legislative requirement or just ticking our box, right? It's about cultivating a culture of data privacy and protection that values the trust of our customers, our clients, and employees. So as we approach this new era in data management and protection in Jamaica, this is an opportunity to meet compliance standards and set an example in data protection and privacy. So the PSOJ remains committed to supporting you in every step of this journey. Once again, I want to warmly welcome you all to this very important webinar and express my gratitude for your dedication to advancing data protection and privacy in Jamaica. I will now turn over to our chair of PSOJ's Innovation and Digital Transformation Committee, Mr. Christopher Record, who I'm sure is known to many of you, and he will do the honors of introducing our very capable guest speaker, Mr. David Gray, this morning. Over to you, Chris.
Good morning, Sasha. Thank you very, very much. Good morning, ladies and gentlemen, for joining us this morning. Very important topic. The Data Protection Act has been in discussion amongst a number of us for about 5 to 6 years, believe it or not. The act had been enacted around December 1, December 1, 2021. At the same time, the Information Commissioner was appointed. Who we have with us this morning is going to kick us off is the Deputy Information Commissioner, who is David Gray. David, as an attorney at law, serves as a Justice of the Peace, and he has been serving in the government, public sector organizations for over 36 years. He holds the designation of Certified Examiner, holds a graduate degree in business from Manchester University, complemented by undergraduate degree in law and finance. David's passion for his alma mater sees him involved in the school, which is St. Mary High School, sits on the board and chairs several committees. Dedication and leadership are evident by his multifaceted contributions to both his profession and his community. So without any further delay, David, over to you to take us through what we all know has been a very challenging time for the last 2 years, where people have a lot of questions, and as much as we try to answer, they keep coming back us with a lot more questions. So the survey Sasha mentioned spoke to a number of things that people were confused about. So I'm hoping you're going to cover some of them, David. People wanted to understand the requirements. People wasn't sure about registration. People, are not sure about where they find, what's a DPO? How do I find a DPO? So David, over to you, and eager to get into the topic at hand. Thank you.
Morning, everyone. Thanks, Chairman. You've handed an awesome task to me, and I hope with the time frame that we have, we'll be able both to fulfill that challenge that you have thrown down and to address the concerns of the participants on the call and in this forum. I am going to share my screen so that everyone can see the presentation. Is everyone seeing it?
Not yet.
All right, hold on. Let me just get it right.
Okay, we're seeing the screen. Just put it in presentation mode now.
Right. I think we have it all well done.
Good to go.
So thanks for organizing this seminar. Thanks for having invited the Office of the Information Commissioner as we try to fulfill the requirements of educating our public on the Data Protection Act. So as our Chris just mentioned, the Data Protection Act, of course, was signed into law in 2020. In 2021, certain sections of the Act were brought into operation, leading to the Office of the Information Commissioner having been established, the Data Protection Oversight Committee, which monitors the operations of the Commissioner, being established, and thirdly and lastly, Jamaica's first Insurance Information Commissioner, Ms. Celia Bartley, was also appointed. For the purposes of the Data Protection Act, it deals with the matter of personal data. And personal data covers information of persons living or deceased for less than 30 years. There are certain unique identifiers, of course, which is the names, addresses, telephone numbers, contact details, your alias name, if you have any common markings on your body. All of that becomes a part of your identifiers, which forms a part of the personal data which is protected. You also have the broad genre of sensitive data, which covers your genetic data, biometric data, and your sensitive personal information. Why the importance of sensitive personal information? Because this data is unique to each individual. It's not commonly disclosed, and the legislation protects it in regards that anyone who deals with sensitive personal information will be required to appoint what the Act refers to as a data protection officer, amongst other things. So what's the role of our office? And the role is that we act as the regulator with regards to the Data Protection Act. And of course, in relation to the discharge of our duty as a regulator, we have the following functions to discharge. We monitor compliance with the Act and any regulations which are made pursuant to this Act. And when we talk of regulations pursuant to this Act, there are two sets of regulations that are applicable. There are regulations which are promulgated via the Office of the Minister, and there are regulations which are promulgated via the Commission. Both regulations will be applicable to the Act and give governance and interpretation and assistance with handling the provisions of the statute. We also will give advice to the appropriate minister in relation to any matter affecting the Act, and of course, matters which will deal with the protection of personal data. We'll also be seeking to observe the requirements on the Act and ensuring that good practice exists amongst data controllers. Critically, as we are now doing, we'll arrange the method and delivery of information about the Act and its operations, and where we are so asked or tasked or the need arises, we give advice to persons about these matters in a manner in which the Commissioner thinks appropriate. We'll also prepare and disseminate preparation of guidelines to be adhered to as good practice. And in doing that, the Commissioner can consult with such bodies as may be appropriate who may have an interest in the subject matter. The PSOJ would be one such body. So having given you an introduction, what is data protection? And data protection is concerned with how the personal data is used by organizations, businesses, or the government. We want to ensure that personal data is kept safe from authorized access. And we want to, of course, by virtue of the legislation, empower individuals to make their own decisions about who can process their personal data and for what purpose. There are some critical terms that all of us as participants, data subjects, data controllers, persons who have an interest in and are affected by the Act, that we all need to be aware of. The first one, of course, is the data subject. That is you and I. And the broad definition from the statute, as you see, is a named or otherwise identifiable individual who is the subject of the personal data. The second most important topic, of course, is the data controller. And a lot of you in the audience, by virtue of representing the various entities to which you are attached, your organization may fall within the scope of being a data controller. And a data controller is any person or public authority who either alone or jointly or in common with other persons determines the purposes for which and the manner in which personal data are or are to be processed. Another most important term is that of the data protection officer. And a data protection officer is an appropriately qualified person appointed by a data controller who shall be responsible for monitoring in an independent manner the data controller's compliance with the Data Protection Act. And the office is aware that several entities are worried about, are there enough data protection officers available? What specifically does the data protection officer do? To whom is it accountable? the data protection officer is the principal officer with whom conversations will more or less be held with the Office of the Information Commissioner in keeping with the Act and the interpretation to be applied to the Act, and to seek clarification of issues surrounding the Act. The Data Protection Officer will also be the chief link between the organization and persons who may have queries in relation to how their information is handled. The statute, of course, does not specify that the methodology or who should be the right person to be a data protection officer. What it sets out to do is identify the fact that the data protection officer has to be a person who when appointed, whatever duties they are required to undertake as a result of being a data protection officer under the Data Protection Act, must not be in conflict with any other role or function to which they may be engaged. And that is the overarching criterion in looking at a data protection officer. Whether that person is a firm or a member of the staff of the organization appropriately qualified, meaning have some knowledge, at least more than a passing knowledge of data protection and privacy practice, be quite conversant with handling and disposing of queries, be in a position to have discussions with the Office of the Information Commissioner and the Commissioner to seek clarity in relation to points. You also have another critical term which you will be aware of, which is the data processor, which is any person other than the employee of the data controller who processes the data on behalf of the data controller. So a lot of our entities, we are the data controller, but some of our processing matters are handled by another entity. The entity that has custody of the information would be the data controller. The other entity that may be contracted to carry out particular activities on behalf of the data controller would be regarded as the data processor. Process, the Act defines as process or processing, obtaining, recording, or storing information, and carrying out operations on the data, whether or not by automated. And of course, we have personal data, which is any information in the possession of a data controller relating to an identified or identifiable living individual or an individual who has been deceased for less than 30 years. The Data Protection Act has, as a part of its key provisions, is the protection of data subject rights. The rights, of course, come from our Constitution, which is the right to privacy. And the Data Protection Act has sought to codify these rights, set them out in a clear and discernible way so that the public and everyone knows the rights to which they are, the rights that they are provided. And all data subjects have the right to access whatever personal information a data controller may have on them. In that regard, they can make a written request to data controllers to provide the details of the personal data that they collect, the source or sources for which they have it, and what's the purpose for which they are retaining this data. And of course, data controllers on receipt of this written request will be required by virtue of the Act to respond within a 30-day time frame. Again, if we link that to the role of the data protection officer, the data protection officer will be the one monitoring to ensure that if there are these requests, that they are handled appropriately, they are handled or notified that of a response within the time frame. And if there's any difficulty in supplying the information, be the link between the data controller and that data subject to ensure that at the end of the day, the data subject receives the rights accorded to him under the statute. A data subject also has a right to prevent processing of their personal data. Now, this can happen where, in several instances, where there may be substantial damage or distress caused by the processing. The data may be incomplete or it's irrelevant, meaning, of course, that whatever data is being collected may not be useful for the purpose for which the data subject is being engaged. The processing could also be unlawful. And a key ingredient of the Data Protection Act, which has to be embodied in your data privacy practice manual, is the matter of data retention cycles, so that data which may be old or not up to date or accurate are suitably destroyed within a stated period of time. Again, this is for the protection of both the data controller and the data subject. In this regard, where a data subject has made a request to prevent processing, that data controller would be required to respond to such requests within 21 days, as stated therein. You also have a right to transmit your data from one data controller to another, data portability. And the DPA will ensure that the data that is transmitted in a structured and usable way from one entity to another. Another pivotal right, which is granted to the data subject, is the right to avoid automated decisions. That is, decisions made solely as a result of automated processes. And the data subject will have a right to have a human review of such decisions and considerations. And the law, in instances, will make the data subject entitled to understand the logic that may be applied behind any automated decisions. Fifth right which the data subject will have is the right to rectification or to correction of errors in data or incomplete information. And you and I, as human beings going about our businesses, we have come across situations where our name may be spelled incorrectly in relation to certain documents and activities and processes. And we would ask that they correct the data that they have on file to correspond to the details of which we have supplied them instead of what they would be retaining. And this situation, the right to rectification, the data controllers will have to take reasonable steps once they are made aware of any errors to ensure that data accuracy takes place within 30 days of notification. What are the obligations of data controllers? One, overarching, of course, is to have an enabling framework to protect the data. But in so doing, all data controllers will be required to be registered with the Information Commission. And registration will mean the preparation of a registration form, which will be furnished to the Office of the Information Commissioner. We are working towards having the system totally automated so that data controllers can log on to our website, which we hope to shortly unveil, enter the information. The information, once submitted to us, will undergo the regular office scrutiny and we'll prepare and issue to each data controller a certificate upon the payment of whatever applicable fee may be stipulated in the regulations, which are forthcoming. A data controller will also have to do an annual data protection impact assessment. This impact assessment will be an assessment of the risks involved in processing the data and indicating the various types of data to which the data controller is processing. Now, the annual data protection impact assessment is due within 90 days of the end of each calendar year. The data controller will also have to maintain amongst their record keeping a record or a log of the data received and any date and time and changes thereto. They'll also be providing data subjects who request it with a copy of their data. They'll also be required to comply with the data protection standards, which I will outline shortly. Very, very important, if there is any contravention or security breach, once the breach has been identified, the data controller is under a duty to report such contravention or breach to the Information Commissioner within 72 hours of becoming aware of that breach. And of course, for the protection of the data subject, notify every affected data subject who the contravention or security breach may be applicable to. What's the critical information that will be supplied upon registration? Of course, the name and address of the data controller, the name and address and details and contact information of that data controller, a statement as to whether that data controller is a public authority. Why? Treats public authorities in a particular category. Once you are a public authority, you are automatically required to have a data protection officer. So once you have indicated that you're a public authority, it leads that you have to answer the questions, the questions which follow as to whether or not you have the name, address, and contact information of your data protection officer. If you are an entity that may not be domiciled in Jamaica, but you do business in Jamaica, you'll of course also indicate the name, address, and contact information of the representative locally. You're going to also, as a part of the requirements for registration, indicate the type of data that you are processing, the categories of data subjects to which it applies, the purposes for which you are processing data, if you are disclosing data to other parties, to name those parties that may be amongst the list, territories to which you may be transferring data, you'll also be required to disclose, and any other prescribed information that may be asked by the commissioner on the registration form. As I mentioned to you before, one of the annual documents which will be prepared by a data controller is the data protection impact assessment, and that is due within 90 days of the end of each calendar year. Right? And that information is going to cover all personal data in the custody and control of the data controller. The data protection impact assessment must include the following information. And this will be in the form of a form. Again, the process we envisage is that the form will be accessible via the online portal. You will complete the form and submit the form in an electronic way. It will allow for ease of processing and handling, and it will allow us a system in which to flag concerns and respond appropriately and quickly to our clients. The data protection impact assessment will involve a detailed description of the processing of the personal data and the purposes for the processing, and the legitimate interest that is being pursued by the data control. You'll also be assessing the necessity and the proportionality of the processing in relation to the purposes for which the information is being retained. You'll also look at the risks, including safeguards, security measures, and mechanisms for the protection of the personal data and demonstrating compliance with the Act. Again, as I mentioned before, the data protection impact assessment will be provided in the regulations which are shortly to be issued. And we hope that that will be concluded and issued before December the 1st, 2023. And I know it's 1 week away, but all intents and all efforts are being made to have this in place by on or before December the 1st, 2023. The data controller, in undertaking their processing duties and their activities, will have to ensure that they comply with the 8 data protection standards. This is the Bible of good data protection governance, and it is the Bible upon which you will build the systems and the procedures to ensure that whatever data is being collected and utilized in accordance with the Act and in accordance with the protection of all data subjects. So we want to ensure that in our handling of personal data, we want to ensure that the processing is done fairly and lawfully. We want to ensure that the processing is done for specific and lawful purposes only. We want to ensure that whatever data that we process or require, that it is adequate, relevant, and necessary for the purposes for which the data has been requested. We want to ensure that whatever data that we are processing is accurate and up to date and as current as possible. As I mentioned before, in speaking, we want to ensure that names are correctly noted, date of birth, addresses are kept current, because information being processed is information that may be required or contact may be made to be required with a data subject. And if the information is neither accurate nor up to date, you could be trying to contact a data subject using an address to which they are no longer living at or is no longer applicable to them. You want to also ensure that in building your platform, that you ensure that the data that you collect is disposed of when no longer applicable. And you will do this by ensuring that amongst your policy tools is data retention schedules and policies, where there is specific statute which may require that you keep personal data for a particular period of time before it being disposed of. Those are adhered to. And when the data is no longer useful or necessary, that it is disposed of in a manner in which it can no longer be rendered usable by any other means. You want to ensure that, of course, whatever processing you're doing is in accordance with the rights, as I previously mentioned. You also want to ensure that within your organization and within your IT and other governance practices, that appropriate technical and organizational measures are in place. That will include ensuring you have user authentication principles in place, encryption modalities are in place, you're using up-to-date tools and software tools which will ensure that there will be no unauthorized access to data, or there will be any compromise to data. And of course, you have the most simple one, which is the clean desk policy, that persons, once they're leaving their desk and they would normally be entrusted in handling personal data, that they leave their desks clean and devoid of any data that anyone can capture. You'll also want to ensure that if as an entity you have to transfer data to other territories, a critical standard is to ensure that that territory to which you are transferring the data also has in place applicable data protection laws. I know it's a mouthful, but I'm going along, and at the end, we hope all the questions that will come either are addressed or will be addressed. So, as I mentioned before, public authorities are required to appoint a data protection officer, and that's standard, a given. Other entities also are required to appoint a data protection officer, right? And a data protection officer is required where you process sensitive personal data, data relating to criminal convictions, and of course, sensitive personal data covers political affiliation, membership in a trade union, health records, genetic data, biometric data. Of course, where you process data on a large scale can mean in terms of clientele, it can mean in terms of geographic distance, it can also mean in terms of the varying types of data to which you are required, also would be required to have a data protection officer. Lastly, of course, if the commissioner requires a particular entity by notice to appoint a data protection officer, that entity or data controller would also be required to have in place a data protection officer. So there are really 4 criteria for having a data protection officer appointed. I'll go over that again. Public authority, it's mandated. If you process sensitive personal data, also mandated. If you process data on a large scale, and large scale can be geographic, it can be amount, also required, and where the commissioner may issue a notice. The regulations, once promulgated and issued, will give further clarity on the any additional guidelines or inputs in relation to the appointment of a data protection officer. And as I mentioned, what are the functions? Data protection officer ensures that the data controller processes personal data in compliance with each data standard and in compliance with the Act and good practice, which is data privacy and governance principles. They'll consult with the Information Commissioner, resolving any doubts about how the Act and its provisions are applied, and if there needs to be any clarity in relation to any regulation. The Protection Officer will also be notifying the Information Commissioner, wherein which, if any information or action which the data controller is required to undertake that the data protection officer reasonably believes is not being done, or any action that is being done contravenes a data protection standard, and where they have been advised to take any corrective steps has not been addressed, then the data protection officer has to, as a part of their duty, notify the Information Commissioner of such an occurrence so that the commissioner can utilize the powers under the Act to protect the rights of data subjects. Of course, data protection officer will also be assisting data subjects in the exercise of their rights under the Act and with regards to the data controller concern. So I mentioned earlier that large-scale processor is also a criterion for the appointment of a data protection officer. And amongst the definitions that you would be looking at in terms of to identify whether you're a large-scale processor, it's the volume and or variety of types of personal data that is being processed. So you have in insurance companies, depending on the type, the amount and quantity of data that's being processed. In life insurance, you may handle sensitive personal data. Again, that will also ensure that you have to have a data protection officer. You're looking at the number of individuals to whom the personal data that you are collecting relates to. You're also looking at a criterion as to the amount of employees that we have. So our example is BPOs and financial institutions, which may have hundreds of employees in their respective branches. Also looking at your geographical extent and whether the processing involves systematic monitoring of behavior. You'll also be looking at whether how your filing system, because we want to make it clear that the law is not only applicable to persons who electronically process data, but of course, those entities which may manually process data, the act also is applicable to them. So how your data may be processed, singular filing system, complex, how long, type of processing, all of these criteria are applied in examining and determining whether you're a large-scale processor and whether or not by virtue of the act you would need a data protection officer. Every act, of course, carries with it penalties for non-compliance. And let us not get alarmed in this transition stage as we move forward to fully implement the act about the threat of penalties. Penalties do exist, but we appreciate from all stakeholders that this is a very new act, and in addressing the complexities of the act, there may be genuine misunderstandings, genuine oversight. And in that regard, what we as an office desire to do is work with our stakeholders to ensure that come the end of the day, what we achieve is full compliance with the statute. But of course, where there are those who we would have worked with and sought to get fully on board, if they don't act accordingly, then there may be fines, and the fines, depending on the level of the court system that it takes place, whether it's the parish court or the Supreme Court, you can have fines levied up to 10 million. You could also have a situation in which you have imprisonment levied by the court for up to 10 years, depending on the type of offense. There is also the onerous one applicable to corporations and their members and officers of 4% of the previous year's annual gross worldwide turnover, which can also be applied in regard to breaches of the Data Protection Act. But as I say, we strive towards achieving full compliance without having to levy the big stick. But the big stick is enshrined in the statute. Various mechanisms can be employed to enforce the provisions of the Act. We have enforcement notices, which gives the commissioner the option to ask that you immediately undertake tasks. Once that is served upon you, if you fail to act, you would have committed an offense, and that offense may carry with it certain sanctions. You have assessment notices where we can enter onto your premises and actually undertake assessments of processing types, and dependent on the circumstances, the type of processing activity that takes place. We also have information notices wherein which the commissioner may require information in relation to activities being undertaken. We can also serve you with those notices. And of course, you have fixed penalty notices that are applicable in relation to certain offenses under the Act. And the fixed penalty would take the place of a fine or confined state of activity. So you have the service or the enforcement, assessment, information, fixed penalty, criminal prosecution in relation to where an act is willfully done, and that person may be subject to imprisonment or fine. Mentioned to you the 4% annual gross worldwide turnover. But of course, I now need to mention to you that notwithstanding any of the other penalties which may be applicable, a data subject who suffers any damage by reason of any contravention of the Data Protection Act by a data controller can sue by virtue of taking out a civil suit, and they would be entitled to damages in relation to any breach or damage that may occur. This is a court-levied sanction, so it takes the applicable provisions of the law to file suit in relation to any breach. So under the Act, the Information Commissioner monitors and regulates the role and activities of data controllers. And this is done through the registration processing, is knowing what is being processed, what and how it's being processed, and of course I'd add when to. Tracking annually your data protection impact assessment to know the changes in your processing that you're undertaking and whatever risks and measures and the provisions that have been put in place to ensure the accuracy of the information. You have the assessment, where the data controller can request an assessment to determine whether their processing activities are in compliance with the Data Protection Act. Or broad compliance function, where of course we can investigate any queries, we can conduct checks and determine accuracy of reports, and any allegations and complaints which the office may have received to ensure their accuracy, a follow-up is taking place, and resolving any matter as raised by the data subject or any manner brought to our attention by the data protection officer, which has not been adequately addressed. We also have the enforcement provisions, where we issue the notices, enforcement, assessment information, and the commissioner, of course, can, by virtue of preparing its report and referring it to the appropriate authority, we may also be enforced a part of or be required to give evidence or affidavits in relation to matters which are being prosecuted by the Director of Public Prosecution for any breach or offenses under the Act. You also may find amongst the monitoring and regulation of data controllers that where there may be disputes, the office can utilize the services of mediators to resolve matters, and the commissioner, having received the report from the mediator, would then make a determination as to how we as an office proceed in relation to the matter, that the dispute that has been acted upon. Can you have the assessments as a monitoring tool? annual DPAs, the request of the data controller, requests that may be made as a result, or the request of an individual. Some of the assessments may be by statute or request, and every data controller is required to permit, facilitate access to premises, documents, information, equipment, processes, and personnel in keeping with the request for the assessment. Now, what do the membership of the PSOJ want to know about how the Data Protection Act impacts on them? And we are aware that there are multiple sectors that the PSOJ in its remit covers. And briefly, here are a few. The accountants and the auditors. So it will affect financial firms in how they handle the client information. Looking at auditing processes, managing financial data, of course, some information in the process of auditing your accounts may have to be transmitted to your auditors for them to undertake processing. So you'll want to ensure, amongst other things, that there are, well, it's a legal requirement in relation to registered companies to have their audits done, but you'll want to ensure that with your auditor, you see that their principles and practices cover strict confidentiality of the financial data or data that is supplied to them for the processes that they will undertake. They'll want to look at the access controls, and you'll want to ensure that they're robust, meaning not transmitted over an internet portal that has no control or not secure. And of course, for the persons who are handling this type of data, you'll want to educate them about data protection principles and the compliance principles to ensure that in their handling of the data, they respect the tenets of the Data Protection Act. What about in your organizations, you have administrative and support services? In this area, you may handle a lot of personal information. Some may be sensitive. So you want to ensure that you have secure customer and employee data. And secure is in terms of its storage. You also want to ensure that it is secured in a secure network. You also will want to ensure that access is restricted to the persons who need to have access to the data. And you may also want to ensure that amongst the persons who have access, that their access is limited for each level of data that they may be required to handle. So you may have a situation within an organization that all that a clerical support may need is just the name and address and a contact number. The managers may need to know more information than that in relation to each category of persons that are engaged within the organization. So you'll want to ensure you have systems in place that allow for that. And you want to more or less say the information or data that each level gets is on a need-to-know basis. You'll want to have in place data protection policies and principles. I mentioned the clean desk approach. And in regard to this area, training cannot be overemphasized. Data protection will have to be something that over time becomes almost automatic and routine. And how we achieve that is by training. What about agriculture? A lot of entities in the agriculture fear process personal data. We have customer databases. We have employees. In relation to employees, we keep a lot of personal data. We have a lot of data on our customers. So we want to ensure that within that sphere, you have your data storage and transmission practices. You examine them, ensure that they are up to date. You want to ensure that you have inbuilt protection and safeguards over employee and customer data. And you want to, again, educate and train employees about data protection. In the area of the arts, a lot of entities, marketing. Marketing is what you do a lot in the entertainment area. Some is direct marketing. Some you have customers who have ticket sales or request tickets, and it's done probably online, maybe done via walk-in, maybe strictly by invitation. So you want to ensure your system safeguard these information, the types of information. You want to train persons to ensure that in handling their data, they handle it with care. You want to ensure that your policy, you're speaking with client and information that is being communicated is applicable to that client. You'll also want to ensure that in relation to marketing, where it may be situations of direct marketing, such appropriate safeguard and permissions are in place for the applicable marketing to take place without breaching the rights of data subjects. Automotive area, of course, car dealerships, service centers. All of us in purchasing a car, if we purchase one, we give a lot of information so that the car can be brought in or bought. And a lot of information is on about servicing of vehicles and pertinent information. So we want to ensure that that data is also protected. We want to also ensure that our communications with our customers in relation to the appropriate product that they may have been engaged in, and if there is any marketing of additional services or products to them, that if we're marketing, it is in direct relation to what we may have previously sold them. And if we're going to be marketing any other product, that the appropriate permissions are in place. So we may have to look at our systems and ensure that the systems and practices that may be in place over many years are in keeping with the present data protection laws. Of course, information in relation to motor vehicles and the types of vehicles may have certain critical information that if it falls in the wrong hands could expose them to I don't want to use the word damage, but to fall prey to miscreants. So we want to ensure that there are access controls in place over our customer databases. And of course, we want to educate every single person from the highest level in the organization to the very lowest level about keeping, retaining, and maintaining confidentiality about the data to which we have access. The financial subsector has a lot of information on customers. So not only for the Data Protection Act, but for other acts such as the Banking Act, the Insurance Act, data protection laws is crucial for them to maintain trust. One data breach can be very costly for these entities. So they will want to ensure that their systems are secure. Sensitive and other information, financial and personal data are kept within suitable bounds, encrypted bounds, access control bounds, need to know bounds. There are international financial reporting standards that they may have to maintain and be in compliance with, as well as international financial data security standards. And as we all know, most of the banking and insurance is worldwide. There are worldwide standards that may be applicable to them. So you'll also want to ensure that in complying with our local law, you comply with those international standards applicable to the industry so that there are minimal or no breaches. We'll also want to conduct regular data protection training for employees. Conduct of this is almost going to be a daily occurrence. Just like we would do a fire drill and an earthquake drill, inbuild this into your annual training policy to ensure that there's constant training, so that employees will know exactly what to do, when to do, how to tell the organization that something has occurred, and to ensure that their not only employees, but data subjects information is adequately protected. And if there is any incident of a breach, that the breach is brought to the fore so that the data subject is protected. Telecommunication companies also have vast troves of data. So they have to ensure customer data and communications are protected. Their cybersecurity measures. Educate. Also want to ensure adequate permissions are in place for direct marketing via text messages. A lot of us get these text messages on our phone. Sometimes we ask ourselves, where did this come from? So read your agreements when you are entering into contracts. Sometimes there are broad permissions that are inbuilt in the contract that when we approve the service to which we have engaged in, it allows for it. So read the contracts, ensure that when we are drafting these contracts, we bring this to the attention of customers so that the customers are aware and can make a fully informed decision as to whether or not they want to opt into this condition or opt out of it. Construction, engineering, real estate industries, again, vast trove of information. Some simple name address, some may also be financial information. Some of it is manually collected and then input on a computer screen. So we want to ensure that we have adequate controls over manual data that is collected, how that manual data is retained, how it is destroyed as soon as the information may be uploaded to a system. We want to ensure that that information, of course, does not fall into the wrong hands. So we want to secure employee, customer, and supplier data. We want to have data protection policies and practices in place for document management. And of course, can't overemphasize, we want to train. Educational institution, which is another entity, they manage extensive student and staff information. A lot of the forms for students entering high school has to be accompanied by a doctor's report, which again is sensitive personal information. So you want to ensure that within the education sector, within each school that falls under the auspices of the Ministry of Education and our educational subsector, they have in place mechanisms to protect the information that they gather, whether it be student and staff information, all the various types. Some of them have suppliers that they have contracts with, canteens, contracts that they administer. So we want to ensure that there are systems in place to protect that information. We want to have strict data policies, and that is inclusive of data retention policy. How long will the organization be required to maintain the data? So you may have active student records, of course. You will may be required to maintain records for the purposes of the issuance of transcripts. So all of that information will have to fall within data retention schedules and data practices to ensure that information is kept securely and safely. And within that setting, again, I can't overemphasize, educate and train staff, but the next generation, which is our students, the earlier we start the education and training with that category, then they will grow into the whole matter of data protection and privacy practices. And in that regard, it will make our future much brighter, and the emphasis on data protection will be inbuilt. Energy, environment, and climate. A lot of data is collected in there, which is also need to be securely handled. And it may also become a part of the whole matter of compliance mechanisms that may be applicable, especially if a data subject is dissatisfied in relation to a certain treatment of the data that may be utilized by this subsector. So you want to safeguard the data. You want to ensure that when the regulations are promulgated, that your activities are in compliance with those regulations for data storage and sharing. You may also want to ensure that you're in compliance with the Act, the relevant standards, and that your processing is in keeping with the rights according to data subjects. You'll want to conduct employee training on data protection. Food and beverage, you have customer data loyalty programs. You may have reservation systems in place, restaurants, food-related businesses. All of this is particular information which you may maintain. So you want to ensure you protect the data for reservations and loyalty programs. A lot of your loyalty programs are indexed to addresses of data subjects, and it gives an applicable profile as to how they may shop. May also tell you whether or not how they shop, whether they are a cash or credit entity or customer. So you'll want to ensure that this data does not fall in the wrong hands, because it may also capture particular details as to financial transactions. So you'll want to inbuild in your programs data protection policies, data retention programs for customer information. Ideally, within this sector, loyalty programs are run on an annual basis, literally January to December, and come December, if you haven't used up whatever loyalty package that you have built up, you technically lose it and you start afresh the following year. So of course, data retention protocols will be extremely applicable herein as to whether or not the information that is being retained has to be retained for a period in excess of 1 year. And you'd want to ensure that this is strictly and scrupulously followed so that information, again, doesn't fall into the wrong hands. Training of the staff within this subsector. Health, of course, sensitive personal data. Sensitive personal data, you must comply with the Data Protection Act and regulations strictly, because this category of information is deemed extremely sensitive and must be safeguarded. You will also have healthcare and safety standards, ethics codes, depending on the various bodies, dentistry, medical practice. All of these bodies have in place ethical standards dealing with patient care records. So you'll also want to in complying with the Data Protection Act, that these data security standards, as required by the healthcare sector, is also maintained. We are very cognizant that healthcare professionals, the entire health structure is an island-wide and a fairly extensive system. So again, training has to take place for not only the practitioner in the public sphere, but the practitioner in the private sphere, because the data that is being handled is sensitive, not only because it's in the public sphere, but also in the private sphere. And we want to ensure that all the practitioners within this sphere adhere to the principles and practices of data protection, governance, and practice. Lawyers, of course, they handle confidential information. There's legal and professional privilege in relation to how some of the information is handled. And of course, the Data Protection Act recognizes that legal and professional privilege and the standards applicable around that. But the legal profession will have to ensure that they protect confidential information entrusted to them. They have in place data protection policies in their firms and in their practice, whether it is a full practice or a sole practitioner. And they have to be aware of the Data Protection Act, its regulations, and what is required under the statute, and ensure that in undertaking their duties and roles and functions, that the tenets and standards are applied with. Manufacturing, a lot of data, production data, employee data, client data, local and overseas, transmitting of data from one country to another. So you'll want to ensure that you secure your employee and supply chain data. You'll also want to ensure that if you have to transmit data outside of the territory, that data is also protected. So you'll want to look at practices in relation to that. You're training your employees on data protection measures. Inbuilt into your safeguards are the practices of enshrining the rights and standards for data protection. Marketing, both from a marketing agency, financial agency, you want to safeguard the customer data that is utilized in marketing campaigns. Data protection policies are to be developed to protect your marketing databases. You want to undertake educating of your marketing professionals on data protection. And you want to ensure that where you are going to undertake marketing activities, utilizing information which you may have stored on file or in-house, that the appropriate permissions are in place in keeping with the data protection. Media, you'll want to ensure they may also have data that they collect, and media may also be cable companies that they collect information on viewership, readership, subscriptions payable, paid. So you want to ensure that they protect the viewer or reader data. They have cybersecurity measures in place to protect the data that they're handling in their respective outlets. You want to ensure that there's no data breach. And we're, of course, doing a lot of public education and sensitizing for the employees in that entity. Those in the mining and quarrying subsectors, they may have a lot of employee and operational data. So they will keep that, a lot of customer data, a lot of international client data. So they'll want to inbuild in their systems adequate protection to cover the data that they may have on. Pharmaceuticals, cosmetic, of course, pharmacies being one subsector may deal with sensitive information. So they'll have customer and patient data. So you will want to ensure that this is kept securely and safely. Of course, healthcare data security standards also are to be in place and to be adhered to. You'll want to educate your employees, not only the pharmacists, the pharmacy technicians, and all the persons who may handle or process customer data in relation to sensitive health data. Those in the cosmetics industries, they may also build profiles of clients, develop particular products for particular persons, which may have due regard for their makeup. So again, that information is also to be kept securely and safely and in keeping with the rights of data subjects as a data control. The professional area, scientific and technical. So data protection will be very crucial here. A lot of sensitive information, sensitive scientific information may also be collected. So you'll have to have systems in place that protect that. Encryption, data encryption software. To access the data, you'll have systems in place that allows for access. You'll have systems in place for processing and storage. And of course, when the data is utilized and the scientific activities complete, that the information is suitably discarded or rendered anonymous so that it cannot be linked to any one person. Of course, sensitive information and persons in this area have to be very highly trained, not only scientifically, but in terms of data protection practices. Retail, again, you may have loyalty programs in place, customer database information in place. So you want to have programs and policies in place to protect this information, right? And again, training staff from the highest level to the lowest level on data protection measure. Technology and telecommunication, extensive data, as I mentioned before. So you want to ensure that there are strict data protection standards, strict compliance with those standards. Information on a need to know and is protected and authenticated. Inaccuracies quickly corrected. Because this information you want to be very accurate and kept up to date. Not only for the telecommunications billing purposes, but for the very protection of the data subject. And of course, you're going to educate on data protection practices within the subsector. Training, a lot of information on academic profiles and a lot of information in relation to individuals and possibly the type of jobs that they may want or the type of services that they may want built, tailored for a specific group of persons. So you want to ensure that your employee and client data is securely kept. You have policies, data policies in place in relation to the services that are being offered, and of course, what best practices in relation to data protection is being adhered to and applied. What do we do now? If you fall within the 5 categories, as I mentioned before, start to identify or appoint, as a lot of you have already done so, to name a data protection officer, which you will appoint when registration cycle commences. You may want to engage practitioners, privacy practitioners, and data security service providers who will do a walkthrough of your activity Look at the types of information that you process. Look at the types of security protocols that you have in place in relation to each level of information that you collect, and to advise you on possible steps you may need to implement or act on to bring your organization up to the level required of the Data Protection Act. Within 90 days, as I mentioned before, you'll also be looking at your privacy impact assessment, but I'm going to further indicate to you the Act requires that you do the data privacy impact assessment within 90 days of the end of every calendar year. But it would be a good exercise in the lead up the process of registration if you get an understanding as to what a privacy impact assessment requires to be done. And there are several examples worldwide that privacy practitioners can guide you through as to what would be the steps required to prepare yourself to conduct a data privacy impact assessment so that it is not strange to you when the requirement becomes due. In a lot of the data practice, privacy practice principles are worldwide. So a basic understanding of what is required from a worldwide viewpoint will assist in dealing with a privacy impact assessment, which, as I mentioned before, the form itself that will capture the detail will be published when the regulations and other documents are promulgated and made public. Have a look at the processes that you have in-house. Look at the statute and ensure that the provisions of the statute are captured in relation to your documentation. Where it is that you may require permission or applicable permission to undertake certain processes, have a look at your documents and see where it is appropriate for you to have those permissions put in place. You may use a lot of online forms. If you are utilizing the online forms, of course, ensure that where permissions are applicable, the area is highlighted and made known to the data subject so that their consent that they're giving is from an informed basis. Look at your access and authorization protocols that you have in place. A suitable time is now to re-examine them to ensure that the authorizations that are in place are applicable to the particular levels of staff that you may have engaged. Look at your whole security architecture. Invest in making it very robust so that if there is a breach, which practitioners indicate to me it's not a matter of if, but a matter of possibly when, that you would have put in place all the relevant steps that is possible within your organization to protect for it. Of course, plan for a liability. A lot of entities, if there is a breach and the breach is substantial and they're entitled to pay out liabilities, it could end up shutting down an entity. So in looking at your protocols, speak with your various providers. Is there a plan that in the event of a breach or there's liability in relation to any data protection failings or any other failings for that matter, that my coverage allows for a claim to be made or liability to be handled in the event. Training, which you've heard me mention so many times, train. From the highest level to the lowest level, It's a participatory training. Every single person has to be sensitized because the Data Protection Act represents a new paradigm. It's going to be probably the first time every single person in society can become affected by a particular statute, other than, of course, GCP. Register as soon as it is possible to do so. And as I mentioned before, registration, the full implementation date for the Act is December 1. Registration will commence as soon as the regulations are issued, and December 1 will be the start of the registration process. Ladies and gentlemen, I have come to the end of my presentation. I know it's a mouthful. I'll lead to any questions which you may have.
David, thank you very, very much for your very detailed, and yes, it's a mouthful, but it is what it is. I do believe we have the Information Commissioner herself, Celia Barkley, on, and she had offered to work with you to help answer some of the questions. At my last count, I think we're just around 100 questions coming in. We have had a few volunteers answering some of the questions for us. And so if the marketing team can allow Celia Barkley to come on and
I will stop sharing then.
Yes, go ahead. Thank you very much, David. Thank you. Great presentation. I have sat through these presentations at least 24 times over the last 3 years. And every time I listen, there is a lot more information that I've learned. And you have done a good job today in clarifying a fair amount of things. So if the team at PSOJ, Commissioner, are you ready to come on? Great. She's in. Okay, perfect.
What I'll do is share the list of questions with her.
Right. Yes. She has been seeing them. She has been seeing them. I have been talking online. So David Gray had mentioned, and just for full transparency, David Gray had mentioned an organization which was created as part of the creating the infrastructure for data privacy called DPOC, the Data Protection Oversight Committee. So for transparency, I sit on that committee. I was appointed by the government to sit on that committee, and I currently sit as chairman of that committee. So several persons have mentioned, asked me direct WhatsApps, aren't I involved in this? So just for transparency, yes, I'm involved in this, and I'm working with the office to ensure that we inform and educate. And David said it over and over and over again, training. David, you're so right. So Celia, welcome. Any introductory words, and choose some of the questions that you would like to handle and some of the doubts that you'd like to clarify. Go ahead, over to you, Celia.
Hi, good morning, everyone. And certainly thank you for accommodating Mr. Gray and me for this session. We know that the PSOJ covers a wide breadth of different sectors. And so notwithstanding, we have had similar presentations before, as Mr. Rickard pointed out, but we know that they didn't necessarily concern all the different sectors. And of course, as we move towards the December 1 implementation date, we are conscious of the there is still quite a bit of uncertainty in relation to how we go forward as a country with the build out of this regime. And we're also conscious that not everyone is at the same state of readiness, and there are certain questions that remain to be answered. So insofar as this will allow us the opportunity to, one, answer the questions, but as well provide some amount of assurance to persons in terms of the approach that we are taking as a nation, then we appreciate that opportunity. All right, now I'd like to say as well, Sir Record did mention that there have been some answers that have been posted in the chat to some of the questions that have been raised. They have been coming in quite rapidly, so I have been trying to monitor it, and I've noted much of the questions as well as the responses that have been furnished so far by the volunteers, as Sir Record called them. Let me just make special note and mention of Mr. Chuck Cameron from Design Privacy, as well as Mr. Ben Rapp, who we know is a data protection officer at Securis Pro, I believe a UK firm that acts for some local companies. So I've noted the responses posed by both those two gentlemen. I'm not sure if I've missed other names of persons that have provided substantive responses, but in the interest of time, I will acknowledge that having gone through, I've looked at the questions and the responses provided and can essentially validate that they are on point in terms of how they relate or articulate our provisions of the Act and how it would impact local businesses. So I'll take those responses as stated. There are a couple of questions, as Mr. Record said, that still remain unanswered. And as I speak, I'm just trying to look through to try and because there are some, of course, that as the regulatory authority, they have left for us to answer, and which necessarily we would need to speak to. All right, so first and foremost, let me just note, there was a question as to the status of the regulations, and I believe Mr. Gray spoke to that in his presentation insofar as where that is, but just for those persons who may have joined late, might have missed that part. For clarity, the regulations do consist of two parts. There are those aspects of the regulations that are required to be prescribed by the minister with responsibility, and other aspects that are required to be prescribed by the commissioner. We do have draft regulations for both the minister and the commissioner, which were put out for consultation with certain stakeholders, mainly in representative capacities. So, for example, it would have been shared with the Jamaica Bar Association as representatives of the attorneys. It would have been shared with the IAJ, the PSOJ, and several other organizations in a representative capacity. And there was some feedback that was provided, that was incorporated. It did lead to some recommendations for amendment of the draft regulations as circulated. And so those recommendations were forwarded to the OPM with a view to being onward forwarded to the CPC for a further draft of the regulations to be issued. At this point, we are hoping that the next draft that comes out will essentially address all the issues made and incorporate the recommendations. And so we'll be able to move to having them promulgated as the official regulations in relation to data protection. Now, we do recognize, as you do, the short space of time that remains between now and December 21, but every effort is being made in terms of expediting those regulations with a view to having them issued and available ahead of December 21. Now, I did note questions further down that spoke to whether or not we would be issuing certain guidance, instructions, directives with relation to firstly registration, but also compliance going forward subsequent to regulations. And yes, that is the intention. In fact, we do have several pieces of draft guidance that are awaiting publication. We wish to await the finalization of those regulations, of course, before officially issuing those as the authority. Now, just going down through the chat, does the DPO need to be a resident of Jamaica? In relation to that question, there is no specific requirement in the Act for a DPO to reside in Jamaica. There's also no prohibition that is expressly stated in the Act against the DPO being outside the country. However, as you will hear as I answer several questions, the consideration has to be based on the requirements that are stipulated in the legislation. And so it will be for each data controller to look at the capacity of their DPO to perform their functions under the Act. Now, when you look at those functions as listed, you'll know that it does provide for or require some amount of interaction between the DPO and management, between the DPO and perhaps other members of staff, the operational units of the organization, some interaction again between the DPO and the regulatory authority, as well as other stakeholders of the country, for example, your data subjects. And so the question is really going to be, if it is that you opt to appoint a DPO that is outside the jurisdiction, will that DPO have the capacity and the mechanisms in place to facilitate the interaction that would be necessary having regard to the functions to be performed under the Act? Now, we also know this is 2023. We are online and Zooming right now. So there is an extent to which technology can assist in facilitating this type of communication. And so it would be a question of whether or not the data controller has the means to enable the DPO to carry out their functions from their location. Now, you will note that as it relates to data controllers that, for example, are outside the jurisdiction, there's a requirement in the Act for them to appoint essentially a local representative to be named. Now, in a similar way, it would perhaps be best practice and recommendation that if you opt to use a DPO that is outside the country to facilitate prompt communication or communication on an as needed basis, it might be in your interest then to look at having that out of country person appoint someone locally that can assist them with carrying out their functions should the need arise. So these are considerations for the controller. As an authority, what we will be looking at is the effectiveness of the DPO in performing the different functions under the Act. Just looking again, when will registration as a data controller end? And I'm going to tie with that a question I know I saw further down that spoke to essentially referring to December 1 as being a deadline for registration. Now, I'd just like to provide some clarification in that regard, because we have seen messaging elsewhere put out by third-party persons encouraging individuals to look at the December 1 essentially as a deadline for registration. So just to clarify, the intention is for the Act to be brought into full effect on December 1. It means that it is on December 1 that the requirement for registration under the Act kicks in. So prior to December 1, it is not possible for anyone to register. On December 1, as was indicated by Minister and by our office at the post-cabinet press briefing in October, registration of data controllers will commence. So it means as at that date, we expect to have the necessary mechanisms in place to facilitate controllers coming forward, starting the registration process. Now, again, for clarity, the process as designed does allow a time within which to be completed. It is not a matter of you will sign on December 1 and have to submit all information, click send, and the process will be complete. So that if it is that you are not fully ready, if it is that you don't have every aspect of the particulars available to you, you won't be able to complete the registration process. You will have some time within which to complete the process. Just to clarify the process again, because we did have some questions being raised for that. We are fine-tuning the development of our website, and the registration process will be by way of an online application linked to that website. So the form, insofar as the act speaks to the requirements for registration, the particulars to be submitted, has been built into the website, so persons will be able to go on. It starts with an initial sign up that requires very brief detail just to create an account to say, okay, I am a data controller. And then using the access credentials that you'll be provided, you'll now be able to log in, access the form, and enter the required information. The information that is there is in keeping with the particulars that are required by the Act. There is some extent to which there are additional information as we are allowed to prescribe. That's one of the jurisdictions of the commissioner under the legislation. And so we have asked for further details in relation to certain things just to ensure that the particulars are properly captured. And so persons will have time to familiarize themselves with the requirements, where the information is available to enter it, where you might not readily have the information available, then to take the time to gather that information and return to the application form to enter it. We have sought to make the application as user-friendly as possible by providing for options for persons to select what is applicable to them, but at the same time recognizing that there are a wide range of controllers and a wide range of sectors that would need to register, allowing some flexibility in terms of persons being able to enter information that might not fit in a particular category. There are some areas I recall, I'm not necessarily going through the questions in order, but I recall a question somewhere in the chat where someone asked about large-scale processors as well. Sorry, I'll find it in the chat shortly, or hopefully before we complete. Now, this is an area
the
for which
document with you. Just hold on, let me share the file so you can go through all the questions. Are you seeing it?
well, I'm
Look in the
seeing
chat.
my meeting chat up. I don't know if you shared something separate. Let me
I
go
sent
all the way
to
up.
you directly.
Ah, okay.
All right, so that's all the questions.
All right, give me a second. Okay. All right, thank you. I'm looking at that now. I was going through address number 2. Well, we were looking at the registration form and where it would be accessed. And I did note one of the responses posted indicating that the OIC would be publishing that information on various platforms, which is in fact the case. As soon as all the arrangements are concretized, we will be issuing notices in the major newspapers, using TV, radio, posting on all our various platforms. We do have social media platforms already up that we have been using to disseminate information to the public. So we do have a LinkedIn page, Facebook, as well as Instagram and X, formerly Twitter. And so we will be using this medium as a way of communicating to various persons. Just to note though, because again, we want to use this forum to provide as much clarification as we can on issues that might be uncertain to persons, as well as to gather information from individuals as to any concerns that they may have, which as a regulator going forward, we should bear in mind. So in terms of the communication to individuals, as I said, we do have draft guidance that we have prepared to disseminate. We are awaiting the finalization of the regulations in order to issue some of those. We have been accepting, and as far as resources will allow, comments or questions from external persons into our office via our general email, which is info@oic.gov.jm. And so one of the things we'll do is, insofar as we're not able to necessarily cover every question in this session, is to try to respond to persons, whether you have sent them directly to us via that email or having received these questions from the PSOJ, then by way of response subsequent to this session.
So
now,
Commissioner, one of my thoughts is that since we have such a vast amount of questions, go through as many as we can. The time allotted to the session was in fact 2 hours. I think we do have 10 minutes left. And what I would like for us to do, as much as your and David's time permits after the meeting, is answer the questions in a sort of a FAQ, and then the PSOJ will send back out to persons who registered for this event. That's my thinking. But you can go ahead and continue answering.
Right. All right. So I see a question here, which I know is important to a lot of persons in terms of the outsourcing of the role of the DPO. Yes, that can be done. There is no requirement, again, that the DPO must be an employee or internal to the organization. And similarly, there's no express prohibition from engaging someone as a DPO. And so we are aware that several entities have opted to train selected staff to serve in the position of DPO, while others have opted to contract third parties to offer that service to them. It really will end up being a business decision for the organization as to how they treat with that, because we are aware that, of course, whatever approach you take, there are certain cost implications to it in terms of considerations for whether it's a one-off cost, a periodic cost, whether you're looking at salaries and additional provisions in terms of pension, health benefits, these things. So some persons have found it advantageous to outsource. Others have, because of the nature of their organization, because of the level of risk that they perceive themselves to have, because of the frequency of the need for the service, determined to internalize those individuals. Just as a follow-up from that note, let me just point out, because we have gotten questions from several persons, well, numerous persons really, to say, well, where do we find these individuals? Now, the OIC, as a part of its authority, does not certify persons as privacy practitioners. However, in recognition of the need for controllers to identify individuals, what we had done was to undertake trying to identify these individuals for persons and publishing a list of persons who are operating in this space, who are offering various services and can potentially help a controller, whether with getting ready for registration or with maintaining compliance going forward. And that is available on our respective pages as well, or can be sourced from the OIC. Similarly, where organizations would want to internalize an individual and have that person trained, we are currently putting together a list of providers of training for data protection officers or data protection services generally. And this, again, is just to facilitate persons in being able to know who they can approach to identify what is available to them to assist them with their compliance. As it relates to groups of companies having the same DPO, I think this question stems from a position that was taken, I believe, in the first draft of the minister's regulation that had seemed to indicate that organizations should not have the same DPO in order to facilitate independence and other reasons. However, as I said, the regulations or the drafts thereof had gone out for consultations. We had a concern regarding that provision, and the similar concern was shared by other stakeholders and therefore relayed to the CPC in coming up with the further draft of the legislation. And I believe that that restriction has been removed such that it will be possible for entities to have a DPO acting for more than one of them within the same group. Now, again, the concern is going to be, as you select your DPO, when you look at the capacity of the person and the workload having regard to the number of entities in the group, the types of entities, their data processing activities, then it's going to be a matter of the capacity of the DPO that you select to serve all the different entities within the group that it is being asked to perform the services for. I'm just trying to look for additional questions that the answers might not have been previously delivered in the group. All right, I'm seeing a question as it relates to auditors and the handling of auditors is how it is framed, and it's from a specific industry, but insofar as several sectors are subject to audit, let me just generally say that persons need to appreciate that the Act does not prohibit certain necessary functions from being carried out. So audit is a necessary requirement for many businesses, whether it is mandated by some law or just as a good business practice. And so it is accepted that audits will continue to take place. The issue that may arise is in terms of allowing the access of an auditor to particular files, to particular information in order for them to do their jobs. Now, in that regard, you will have to look at your own practices, your files and records, as well as any specific legislation that is governing your particular sector to see what obtains for you and how it applies to you. We certainly are not taking the position to say that audits can no longer be conducted because this now would be in breach of the Data Protection Act. You will have to put in the necessary machinery to ensure that with facilitating the audit, you're nonetheless able to do so in a way that is respectful of the standards in the Act as it relates to things like access, data sharing, the purpose for which persons are processing the information. And recall that any use of information does form a part of processing in the Act. Is there a standard consent form that the DP will accept, or should we create one? There is I believe there's a prescribed form in one aspect, but don't quote me on that. Let me double check as it relates to that and the final position that was taken, because it was contemplated, but there was some debate as to how restrictive it would be, and of course the cost to organizations if they are now asked essentially to change their processes and adopt something that they weren't previously provided for, where they may have already had something in place that provides a similar function. This request was also addressed. I believe this was also addressed. Sir, I thought if you want to assist me, because I'm trying to go down as quickly as I can while recalling what has not been answered. When will the website be available? I did mention we are finalizing and intend to go live ahead of the December 1 date for persons to be able to access that. Will the DPA take effect in 2024? Let me say a very strong no. And in that regard, let me just shed some light on the implementation. So it is proposed to proceed with the December 1 implementation date of the Act in terms of all remaining sections not previously brought in place, now being put into effect. When we speak to a phased implementation, as the minister mentioned last month, what we're really looking at is, out of an appreciation of the state of readiness or lack thereof of the various stakeholders, how can we facilitate persons complying as far as is possible now, but having some time as we go forward to become increasingly more compliant? And we have to do that having regard to, first and foremost, our own resources, as well as the resources of the persons that we are requiring to comply with the legislation. And so in that regard, and trying to strike a balance, what we have essentially contemplated is proceed with the registration of controllers. However, try to focus first and foremost on those controllers that we think are most critical. And this is not to say that all controllers are not important or that there is an equal level of responsibility imposed by the Act on all controllers, but recognizing that for various reasons, some controllers ought to be given priority. So, for example, the level of risk that may be posed to data subjects by certain controllers is perceived to be a little higher. And so for that reason, the intention is to proceed with certain priority categories. I can share with you that in terms of those categories, what we are looking at first and foremost are the public authorities, naturally based on their nature, their role, their function, the volume of data that they could collect, and the different persons that would be affected in the event of a breach. Then public authorities are among the first controllers that we would want to come forward and start registering as at December 1. Also identified as priority persons are those persons in certain sectors. I wouldn't say vulnerable sectors, but sectors in which, because of the nature of the information that they have, there might be a little higher risk to the data subject. And so we're looking at the persons in the education sector. We're looking at the persons in the health sector because of the sensitive data they might have. We are also looking at persons in the financial sector, both in terms of the types of data as well as the volume of data that they may process and its impact on persons if there's a breach. So those have been identified. Oh, also persons in the telecommunications industry, and we're including in that companies operating BPOs. So those, and we'll issue the notice with further details as to the categories of persons, which as a matter of priority, we're asking to come forward December 1 and as soon as possible thereafter to register. That notice, when published, will also include further details as to the registration, instructions on how to register, how to make payment, and things of that notice. And we will circulate it as widely as possible, including through the various membership associations, because we're well aware that sometimes you publish things, persons may miss it, notwithstanding it's in the media, you place it on the radio, persons again may miss it for one reason or the other. So we aren't limiting the means by which we will be disseminating the information going forward as to how persons can register.
All right, Commissioner, I think we have come to the end of the time allotted to us. I know that lots of people are firing some last minute questions, and as promised to the attendees, all 470 that still remain, I think we got up to as high as 510 at one point in time. So this indicates the level of interest that folks, especially members of the PSOJ and other organizations, it indicates a level that of interest around the challenges that they face, because again, as started out, our executive director outlined the fact that we did in fact do a survey, and we did in fact have a list of questions and concerns that folks were had expressed to us. So, ladies and gentlemen, it's been a very informative morning. I know that still questions are still firing in. I saw like 3 or 4 or 5 coming a while ago around people who want to know how to get on the list. And I think that, the commissioner kind of explained that. And because I was close to the process initially, this list was done, Commissioner, correct me if I'm wrong, at the very beginning of putting together the organization of folks who were in the industry at that time. Now, between 2021 and today, a few more people have joined the industry, and I think folks want to find out how to get on the list. So I don't know if you want to answer that now, or want to send out that. But go ahead if you want to answer it now. As a last question.
As you said, when we started at the time, we had reached out to known practitioners and asked them to provide their information, as well as that of other persons with whom they would have been familiar. We got, I believe it was 12 responses at the time. And so those persons were published. We have had persons writing to us to indicate that they too provide a service and ask to be included. And what we have been doing is updating it as we go along. I think by now it has perhaps doubled. Last time I looked at it, we were somewhere in the mid-20s. And just to be clear, what we have done is to provide a breakdown in that as to the main focus areas of the practitioner. So there are persons who focus more on the aspect of privacy and being able to guide you in terms of compliance with the privacy aspects of the legislation. But we know that data protection speaks to more than that. It speaks to privacy, it speaks to governance, it speaks to security. And so we have also identified those persons that look at it from a security perspective. So you do have the law side, the IT side, whether the person offers a general rounded type of consultation, but it remains for each person to determine as to what services they require, and of course to contact different individuals to see who would best meet their needs. Persons who are in the space operating, whether as legal practitioners, privacy specialists, security specialists, who want to be able to assist data subjects, data controllers, guide processors, DPUs, you can be listed simply by sending an email to info@oic.gov.jm and requesting to be added. We ask that individuals provide, of course, basic contact details, name, address, email, contact numbers, and of that indication as to what it is that you offer, whether it is just the legal aspect, the security aspect, or a full range, as well as whether you are offering your services simply in Jamaica, regionally within the Caribbean, or internationally, because we're aware that some controllers are not just operating locally, and so their concern is to be able to identify somebody who can serve not just their local company, but also their counterpart associations elsewhere. So that is also included. But once you write to us, we will respond indicating what is required. And once you send back that information, as I said, we update the listing so that persons have an idea that they can reach out to you for assistance.
Commissioner, one of our team members at the PSOJ is asking if you could quickly mention the cost of registration. I mean, I'm not too sure if you're ready to do that yet, because I think we still have some approvals to go there.
It is to be prescribed in the regulations, and so insofar as it has not been finalized, I'm a little reluctant to say. What I will say is it's manageable at present. It is to be reconsidered having regard to certain concerns that have been raised, and so there may be a variation by the time the final regulation comes out.
And just repeat the email, I guess.
But as an incentive to, they're hoping not to kill you.
That's true. I've seen the numbers, folks. Don't worry. It's not frightening at all. Commissioner, could you just repeat the email address for the folks? A few people are asking.
It's info.oic.gov.jm. sorry, info@oic.gov.jm.
Great. Ladies and gentlemen, again, thank you very, very much for taking the time this morning, investing these 2 hours with us, the Private Sector Organization of Jamaica, in association with the Office of Information Commissioner, to inform and educate around the Jamaica Data Protection Act. The Act comes into, I guess, full enforcement, or some enforcement, December 1. The minister did, in fact, outline, further to the PSOJ, making requests for some sort of a consideration recently around what is to be enforced, what will there be some time allowed around. So we're expecting more communication out of the minister.